Hi guys, good afternoon. Thank you for coming to the talk. Wasn't expecting so many faces here. So as Julia said, my name is Deborah Acquaah and I work as the Assistant Legal Officer for Social Security at a small little charity called the Free Representation Unit. Some of you may have heard of it, depending on what stage you've reached in your studies at the moment. But basically, the Free Representation Unit was a charity that was set up about 40 years ago by a group of bar students while they were studying, primarily wanting to assist those who were in need of getting access to the justice system, but also as a good way for them to develop and further themselves as they were moving into their careers at the bar or in law generally, so they could develop their skills further and utilise them in a nice altruistic way. It's been running now for over 40 years. I think we're coming into our 45th year next year. We're based just around the corner from Gray's Inn at the moment. Shortly be moving, but just towards Holborn Station, so we'll still be in and around the area. So basically, the two main areas that we assist people with representation for are employment tribunal hearings and social security tribunal hearings. Employment tends to be one area that people come across more often because you'll do it as part of your law degrees. If you started on your LPC or on your BPTC, you may well be looking towards taking the module as an option towards the end of the year. Social security is one people don't often hear about or have come across. Essentially, it encompasses people who have hearings with regards to welfare benefits that they're receiving or welfare benefits that they wish to claim. So in a broad spectrum, it sort of touches upon public law, administrative law. So if there's anyone interested in that side of the law, then this is a good place to get your foot in the door and start seeing how the law works in that area. We assist in employment tribunals and social security tribunals in London and the southeast of England. We are a London-based charity, so we have on occasion had people outside of London wanting our assistance, but unfortunately we don't stretch that far. But the number of tribunals that we do attend is quite a lot. I think the furthest we go out is sort of Portsmouth, Southampton area, because there's a few employment tribunals down that way. So initially it sounds quite small, but there are scopes to go a bit further out of London. That in itself gives you sort of a good idea of how the bar will work. If you do go on to get pupillage, you will find that you'll probably be shafted off to different courts and county courts and high courts in and around London or just outside London if you end up being London-based with your pupillage. So it will give you a good idea of sort of the travel that is involved with your pupillage and attending different courts in and around London and just outside of it. So to become a volunteer for FRU, it's sort of a 4-step procedure. So the first step in becoming a volunteer for FRU is to attend one of our training days. So we hold training days 3 times a year. We normally have a training day early in the year around January or February. We have a training day during the summer period around May or June, and then finally a training day in October, September time. The training days we hold 3 times a year, and those are the opportunities for you to begin your training with us. We have a booking system where you log on through our website to book yourself onto a training day and to attend. Training day normally lasts for a day. It's usually held on a Saturday, so it's from 10 to half 4 p.m. And it's basically us going through the basic areas of the law for both employment and social security, the sort of types of cases you'll come across quite often with those 2 areas with regards to volunteering, basic legislation about it, and also sometimes the tactics behind going to the tribunal and things that you don't necessarily get taught by reading a book, because our legal officers have been doing this for over 15 years, so they're quite versed in knowing the tricks and the trades of attending the tribunals and what things to look out for. So once you've attended one of our training days, the next step is to pass one of our tests. We have a test for both employment and social security. There is only a requirement to pass the test once. So if you end up attending a training day for employment and also a training day for social security, you only need to pass a test in one of those areas to then proceed to the next step. Both the tests are based on statutory interpretation, so we'll give you a factual scenario, we'll give you the bits of areas of the law to look at, we'll give you bits of legislation that also may not be relevant to the question, so it's a case of trying to figure out which parts are the parts you need, apply the legislation to the facts and answer the question posed, and that's sort of the basic step around it, and hopefully if you do those three in a good enough order, you'll pass the test. There are examples on our website of questions, past questions we've set, and past answers. So do have a read of those. They'll give you an idea of how to answer the test. And also generally, just for you as a study point of view, it's a free source to look at with regards to how to answer in statutory interpretation questions. So after you've passed the test and you've been told you've passed the test, we encourage you to go along to observe an employment tribunal or a social security tribunal. The closest ones to Gray's Inn at the moment, we've got the London Central Tribunal, which is just off Kingsway, just a few stones walk away from Holborn Station or from Temple Station. And then the Social Security Tribunal is Fox Court, which is just opposite here, Gray's Inn itself, just off Gray's Inn Road. Those are the two closest tribunals that you could attend. The tribunals work in a more informal way than a county court or a high court, if you've ever been to one. They tend to take place in a room about this size. You will have a panel of judges on this end. Client will sit on the other side with their representative. So it's quite informal. It is open to the public, so do go along and observe one. Best thing is to just talk to one of the clerks who are there on the day, mention that you're a law student wanting to observe a tribunal, because they just need to check often with the claimants whether they would be happy to have an additional person observing. Most claimants will probably say yes. They may well try and ask you questions, but do just explain that you're here to observe solely, in case they do want to pick your brains on anything. Once you've observed the tribunal, we then ask you to come to an office induction at our office. Normally takes place every Mondays at 6 p.m. And the office induction is generally just to introduce you to how our office works, how the process works with when you want to come in and pick up your first case. We'll show you all the different resources, books, and access to the law that we have available in the office, and just generally explain what to do when you first want to come in and look at cases and decide if you want to then take one out. So that's sort of the 4-step procedure to becoming one of the volunteers. The way we get cases referred to us is primarily through organisations who are signed up as referral agencies for us. They often tend to be legal advice agencies. They often will be citizens advice bureaus, law centres, and we found that due to cuts in funding and where they maybe used to be able to send people along with people to their hearings, they no longer have the facilities and capabilities to do so. So they'll often help the client in initially putting in their applications, in helping them put together their arguments for claiming the benefit or for claiming that they've been discriminated in their employment or unfairly dismissed. And then when it comes time to them being told that they've got a hearing coming up, they will then refer the case to us to see if we can find one of our volunteer representatives who will be available to attend with them on the day. So they come through to us by post, by email, and sometimes are hand-delivered to our office. The initial bundle itself, is what we call it, consists of a referral form signed by the client just to authorise their data being on our system. And then for employment, it will often include the initial ET1 claim form. If the respondent have put one in, then it will include the ET3 response form. And then we also ask that they include a copy of the notice of hearing just to confirm what day their hearing's taking place, the time and the venue. For Social Security, it will involve the notice of hearing and also the bundle, which is often prepared by the Department of Work and Pensions. So point of note, if you do Social Security cases, you will find that you often don't have to prepare a bundle. If you do employment, you may well find you are preparing a bundle from scratch. Also good experience, but just bear that in mind when you're deciding to come along and volunteer with us. You will get stuck in straight in from the deep end. So those are the ways the cases get referred to us. Once they come to the office, they are processed, the client's details are put onto our database, so we have easy access to it. And when you initially come in, the cases are all available in folders at the back of our office. There tends to be more than one case in each folder, so we ask when you come in not to take the whole folder away with you. Take one case out at a time, sit down, have a read of it. Feel free to spend as long as you want reading it. Some people spend time reading it and then decide they don't want to do it, but they just want to get a feel of how the case will actually work and what they need to look at and think about when they're deciding if they want to then go on to pick up a case. Our case files all stay in our office, so you will need to be coming into our office to work on them, mainly because of confidentiality reasons, data protection legislation and reasons as to why we hold the case files in the office. But it's very easy to make notes off of the papers, and you can take your notes away with you so long as you don't include any details of the client on them. If you're wanting to take out a case, you can speak to either myself or one of the other legal officers, and we can sign that out for you on our system, or have a word with our receptionist, and they can sign it out for you. And then once you've signed out a case, we ask that you come back within 2 days to then have a proper chat with us about the case. For Social Security, we have ratification guides. The meeting is called a ratification. Essentially, we just give you some guidance with what parts of the area of the laws you should look at, which legislation you should be looking at, the types of questions you should be thinking of when you're looking through the bundle, making sure you've got all parts of the bundle, so there are different forms that the bundle will contain, so we normally tell you to look out for those form names so that you've got them all. Tends to include a questionnaire of some sort, a medical assessment, and then the actual decision itself. Employment, they don't have a similar ratification guide, but if you ask the legal officers, essentially it's the same sort of thing, just looking at what the actual issue is. If there's anything else that crops up that the client may have not mentioned in the form, sometimes they mention discrimination of some sort somewhere, so just to make sure that you've noticed that, and if you need to at conference ask them a bit more about it, and just ensuring that you do have as much paperwork there as you need initially to go off of, and making sure that you're looking at the right relevant legislation provisions as well with regards to thinking about the claim that they're bringing forward. So once you've come in for a ratification meeting, that's our way of assessing that we think you're on the right track with it. If we do, we'll let you know to get in touch with the client. You can call the client from our office. It's probably preferable to do so rather than off of your own phones. And when you call the client, it's initially just to sort of remind them about the fact that the case has come to us. Sometimes clients have done it so long ago they forget that it's been referred, but also just to check that they are still looking for representation, ensure that they don't have a representative in place, and if they don't, then you can then offer representation for them, and arrange to meet them for a conference. We suggest meeting them for conference at our office. Again, for some of you, this might be the first time that you come in contact with a client one-on-one doing your own conference. So we find it's a lot easier if you do it at the office. You still have us on hand at any point during your conference. You can just take a pause, pop out, ask us any questions, raise any issues and concerns you have. And it's our way of also keeping an eye on the clients. Most of them are really lovely and will be super grateful for the representation that you're offering them. But occasionally, particularly Social Security, depending on the conditions the clients have, particularly if they suffer from mental health conditions, then it might be a bit more helpful if they're in the office, where you can then get quick access to us if you have any questions or any concerns when the conference is taking place. We normally say probably to set about 2 hours for your initial first conference as a guideline, but you'll find if you do take up more than one case, you may well find that you're doing conferences within an hour. It's good practice for when you go into your careers to be able to know how to do a conference. It's tempting to sit there and listen to everything the client's ever happened in their life, but you're there to do a particular job, which is to represent them at their hearing. So you're wanting to find out key bits of information about their case and how you could then make good arguments on their behalf. So you will learn that sometimes you might have to be quite assertive with the client and pull them back onto track. Other times you might find it's actually useful to sort of let the client just wander off a bit with their story. You might find you get a bit more information out of them if they do just talk for a bit, and you can then cherry pick those bits of information out afterwards. Also with client conferences, it's important with client conferences as well as with any correspondence you make to make notes of your correspondence. If it's telephone calls, we urge you, really, really important to keep notes of any telephone correspondence you have with your client, with any other parties with regards to the case, particularly when you're in your conference, to make notes again, partly because it's difficult for you to remember all this information despite how intelligent you all are. You probably won't remember every bit of information the client gives you. But also it's important because if the client wants to ask questions about things that's happened previously, you can then confer to notes. And it's easier for you to point to a note version form of what was said as opposed to saying it off the top of your head. Clients can sometimes be distrusting of the judicial system and anyone involved with it. Mostly on good reason. If they've been in the system for a long time and they've had difficulties with it, they may well find it difficult to trust you straight off the bat. So it's a lot easier if you've got a written note of anything that's happened, anything that's been said, to show them and document. And also for case management purposes, when you're doing cases, you want to make sure that you've got a written record of things that have taken place, things that have been said. It makes your life a lot easier when it comes time to closing the case. And also if the client does want to request any other documents from their file at the end of the case, then it's easier for you to provide a written version of it instead. So once you've had the client conference, you will then be able to start working on preparing your arguments for the hearing itself. So for Social Security, you tend to put in written submissions to the tribunal about a week or so before the hearing takes place, and that tends to be your main point of arguments, the main way you'll present your arguments to the tribunal. Written submissions shouldn't be any longer than about 3 pages. Kind of works in a similar way to skeleton arguments if you started looking at them, but you provide a bit more information on your written submissions as opposed to a bullet point version of a skeleton argument. We do have guidance in the office with regards to writing submissions. We also have a textbook written by one of the Social Security judges, Judge Jacobs, which goes into a lot of detail about how to structure your submissions and the content to include in your submissions. But if you are struggling, we're also there to give you any tips and pointers, so feel free to come and ask us any questions. We do ask you also book yourself in for a submissions appointment for about an hour in length, although it might take shorter than that, again, so that we can go through the submissions with you, point out anything that might be not particularly relevant or pertinent to the case and you should probably take out, and also give you any pointers on bits that maybe you might want to flesh out a bit more, because it's quite key and important that the tribunal understands that point of the argument for you and for your client. Social Security, once you get to the tribunal itself, you'll find that the judge will look at your submissions and they will mainly be going off of your submissions. But there still may be opportunities to orally present arguments at the tribunal. They often will be asking the client's questions and wanting the client to answer. But if there's any points where the client is finding it difficult to answer the questions, doesn't understand the question, or they just require you to add a bit more to the submissions that you've put forward, they may well then look to you to then provide those answers. For employment cases, you don't write submissions per se. It works in quite a different way. What you may find for your employment cases is you're drafting a lot of different documents depending on at which stage of the case you come in. If you come in at the very beginning, so if you get a case where it's literally they've just been told that they've got a hearing and they've done nothing else, you may find that you're drafting witness statements, you are drafting the schedule of loss itself, you are in constant talks with the solicitors for the other side with regards to potentially negotiating a settlement. If you come in towards the end, documents may have already been drafted, they may have already been exchanged. You may look at them and decide that there's absolutely nothing wrong with them and you're happy with the documents that have been put in. Other times you may look at it and if you've got a bit of time left, you might want to redraft them again. Again, something to talk to one of our employment legal officers about, and they will let you know, because often these are clients who are acting as litigants in persons, even when they've put in documents, particularly with schedules of losses, you may find that they are claiming quite outrageous amounts of money, and it's probably better if you do redraft the schedule of loss to make it a bit more easier, more realistic for them if they are looking towards settlement, for the other side to be more open to their settlement offer, as opposed to claiming 1 million for an unfair dismissal, for example. Again, with any of the documents that you need to put in, we're here to give you pointers, we're here to give you tips. Please, please, please come and talk to us about them before you send them off. It's really important, not only for you, so that you learn and develop your skills with regards to drafting, with regards to what to look out for, with regards to what to include when you're putting things down in written form, but it's also really important for the client. You don't want to put things down and then send it off and then come afterwards and mention it to us and see a really confused and blank or quite angry face, because maybe we've included something that wasn't quite right on the right tracks for the arguments that we're wanting to raise. Once you do a lot more cases, you'll find that you'll get your head around doing things and it'll be easier for you to pick things up. But we ask initially just to come and talk to us. Even once you've done a few cases, it's probably always best to come and speak to us first, just to run it past us and get approval. You might find that the legal officers are happy with the arguments that you're putting forward, but it's always worth checking first. And also when you go into practice, these are things that you'll be wanting to do as pupils when you're checking things with your supervisors, and even once you start practicing, you may want to check with your fellow peers, with your more senior members of chambers or your more senior members of your firms, whether you're on the right tracks with regards to drafting things, or you're on the right tracks with regards to the arguments you're raising in a particular case for a particular issue. So it's really important you check things with others as well, before you sort of send them off as your final drafts and things as well. So in preparation for the hearing itself, like I said, Social Security tends to be based on your written submissions, although there is still scope to potentially orally submit things at the hearing itself. Employment is the area of law where most of your submissions will be orally at the hearing. So obviously you'll put in various documents before, which will sort of set out the story and the arguments for the client in regards to the claim they're bringing, but you will then often go to the tribunal hearing itself and you will need to present these arguments orally, whether that's through examination in chief of your witnesses or cross-examination of the other side's witnesses. So you'll find that there's probably a bit more scope to do oral advocacy for employment, but it's still just as important the written advocacy and preparation you do beforehand, because if you've got great preparation, then you might find that you don't need to say very much in tribunal. The judge may read everything that's come before and just ask a few questions, because they've basically seen that your side of the argument is the one that seems to be the correct version to look at. Preparation as well, even if you do find that you're speaking a lot at tribunal, always good to have great preparation, because then you at least know where you're bringing your arguments from, which order you want to present your arguments in. And also you need to think about what arguments the other side may raise. Most times your employment cases will not be perfect. There will be flaws in your employment case. Your client may have very good, strong arguments in favour of them, but they also may have things that really bring up issues of potential contributory fault on their behalf as well. And you can bet that the other side have picked up on those and will be bringing those to the forefront. So if you can prepare beforehand by looking at what flaws are in your arguments, what holes are in your cases, and trying to figure out, one, what the respondent may say about them, but also what the judge may think about them, and have answers in response to them, then that just helps you, again, once you get to hearing, if any questions do crop up, you can answer them really clearly, really succinctly, and quite confidently. Learning how to bring a bad argument in your case, and sort of make it look not so bad, is a great skill that you will need once you get into practice again, because it is very rare that you will fall upon a case that is completely and utterly perfect. So you will need to learn how to look at both sides of the arguments and ensure that you've got answers ready for both sides of the arguments that may be raised. So once you've gone to your hearing, you will normally probably get the outcome, whether it's by decision notice for social security cases or by judgment from employment tribunals. They will normally come in the post. Occasionally for social security, you'll get the decision on the day, handwritten, depending on how easy it is for the tribunal to decide based on what you've written in your submissions. But often or not, it'll be coming in the post. So when you're going to tribunal, you will sign out the file from the office, and then when you return to the office, you will sign the file back in and put it back into storage. When you're bringing the file back, you can sit down and have a quick chat with the legal officer about what's happened. If you think potentially it's been a really good day and you want to just sort of say what went well with it, feel free to do so. Again, if you think or you're a bit concerned that certain things may have not gone the way you planned them, feel free to sit down and have a chat with us about it. It's so often nice to just get it off your chest and out of your system, and discuss it that way with us. But you'll probably then need to come back into the office maybe a few days later or a week or so after to then pick up the decision itself, and then come and sit and talk with us about the decision, if we're happy with the decision, if we think the client will be happy with the decision, and if the decision doesn't go our way, then if we think there was anything legally wrong with the decision, which we could potentially put to an appeal on behalf of the client. Judgments for employment tend to take a lot longer than a week or so, so you might find that you'll be working on other cases or doing other things before your judgment returns to the office. We still ask you to come in within a week or so of the tribunal hearing, even if you haven't received the judgment or the decision yet, because it's always worth just keeping your client up to speed as to where you are. Give the client a quick call, let them know, unfortunately, that we haven't got it yet through, and once it comes through, I'll be in touch again to discuss it further with you, just so that they're not worrying too much about it as well. If you do get your decision in quite quickly, and it's all gone the way the client wants and they're happy with it, then you'll need to come in and have a closing appointment with us so that we can close the file properly, and make sure that the file gets sent off for archiving. For data protection purposes, any cases that we represent, we have to hold on to the file for at least 6 years, in case the client wants to request a copy of the file back again, then we can then provide it to them. But we don't keep the files in the office, they get sent off to external storage for archiving purposes. But you need to come in and ensure that the file is closed properly. So that involves adding any correspondence you've had with regards to the case, whether it's electronically by email or written documents that you've made by hand or typed up. We need hard copies printed off of those documents and attached to the file. Once all of those documents are in the file, we keep one hard copy version of it all, and then anything else needs to be deleted off, so that everything is contained in one nice little parcel that can then be sent off for archiving. Closing cases, again, it's really important you learn how to manage your case right through to the end. It's all well and good if it goes well and the client's happy, but if you don't close the file properly, you may leave yourself open to potential issues of negligence, particularly if you haven't kept your client up to date with regards to what's happening. Also, if decisions come in and you don't come in and read them and you don't come in and check with us what they say, you may well have clients who had grounds of appeal based on legal errors, but because you haven't kept up with them, you haven't closed the file properly, it's now too late for you to raise those as arguments. So it's really important that you close your cases properly, just as important as how you run the case as it's happening and how you initially open the case, because there are still scope for arguments to be raised with regards to the case and to the file itself. And also when you practice, you need to be able to close your cases, make sure that you bring the case to a good and nice tidy end, and ensure the client is fully happy and satisfied with the result. for their sake and also for your sake. You don't really want cases sort of hanging and hovering over your head, and 5 years down the line you're getting someone chasing you trying to figure out what's happened with this case. If you keep your eye on the Bar Standards Board and some of the disciplinary hearing cases that they've come up against recently, it's often been to do with people who haven't been keeping contemporaneous notes of correspondence as they've gone along. The case has ended and now something's come up, and then they're backtracking, realising that they haven't actually done things in the right order or closed the file properly or kept good notes of the file, and that has then led them open to negligence claims. So it's really important, guys, that you make sure you've got all your case file management skills up to par. Again, it's stuff you'll start learning as you're going through your careers, as you're going through your studies, and this is just another great opportunity for you to really put those into practice and start honing those skills and getting them right up to scratch, because there may not be a lot of opportunities where you can individually focus on those things. So that's essentially the life and story of cases that come to us and how you'll be able to volunteer. I mean, we've got a lot more information on our website. You can feel free to give us a call or drop us an email at any time, and we'll try and answer any questions that may not have been answered either here or on our website. But I really, really hope you do consider coming along to volunteer for FRU. It is really great and worthwhile for your skills and your development, but also for the clients that you're helping. A lot of them will not have been able to go to the tribunal themselves, and just having that additional support has really changed it. And I think statistically a lot of hearings that go to appeal tend to get overturned, so it's quite a high, I think at the moment for Social Security is about 60% of cases that go to appeal get overturned, and that's because of the presence of a representative. So it often does help a lot more to have someone present.
Thank you, Deborah. That's really interesting. We can clap, but should we ask a few questions first? Who wants to ask Deborah the first question? I reckon we've got 5 minutes, and so let's try and cram as many in as we can. Who'd like to? Would you like to ask the first question?
So if you get like a mentoring, like during the case closing or something, do they mentor you throughout the?
Yeah, you get supervision throughout. That's part of the main job that I and our other legal officers are here, is to supervise you from the beginning of the case right through to the end of the case, which is why we ask you to ask us any questions you need to. I mean, our principal legal officer, Emma Baldwin, for Social Security, she is also a part-time judge, so she's great with the tactical side of going to tribunal, as well as looking at the legislation and the actual rules surrounding the cases. Michael Reid, who is our principal employment legal officer, is on a number of committees with regards to employment law. So again, he is a great source of information, not only for when you're running your cases, but just generally and looking at how the law operates in this sphere of your legal career. But yeah, you'll get supervision throughout, which is why we're here. So please do come and ask us questions. We really don't mind.
It does sound like you have plenty of support, actually.
Yeah, you've got us, but you've also got your other volunteers, and you'll have volunteers who started the volunteer journey just like you guys while they were studying. They've then gone on to do pupillage or their training contracts, and you'll find that even now that they're practicing either at the bar or as full-time solicitors, they're still dipping in and out of the office because they're taking on maybe some of our more experienced complex cases. And when they're in and around the office, they again are a beacon of knowledge. They tend to not mind you asking questions, so feel free. Maybe don't badger them too much if they are trying to focus and work on the case. But they're more than happy to answer any questions you have, particularly if you are wanting to look towards doing more complex cases, either at the upper tribunal or the employment appeal tribunal, then they may be great places to start by asking questions.
Any more hands up if you, yes, just here, and then I'll come to you in a minute.
In regards to writing submissions about when you're working on a case, is this something that we'll introduce when we come to training days, or is it something that we learn along in the whole process with the support that you guys provide?
We mention it briefly at training days, but training days tend to focus on just making sure you're relevant of the law itself and what sort of the basic cases that you'll come into contact with when you initially come to FRU. Submissions, we'll have meetings with you. You can have appointments with us, and that's where we'll go through it in a bit more detail, because it's a bit more specific. In our training days, to sort of to give you a general overview of how it works at FRU, but you can get additional support once you're in the office with submissions.
Excellent, thank you. Just here.
Hi. So if we're not based in London, like currently student, is there any way we can be involved? Like, can we come in over the summer and do it? Are we able to sort of? Is there any support for travel? I mean, how do people do it like that? Or is it sort of
Yeah, I mean, FRU's open the whole year round, and we get cases throughout the year. So if you're not based in London studying, there's definitely scope for you to come in. We do have volunteers who live outside of London who will come in and volunteer. They may try and just time it a bit better. So if they know they're going to have quite a free period at a certain point, then they may look to either coming in to pick up cases then and trying to run them that way. Do speak to us if there's any practicalities about volunteering. That's again what we're here for. Travel wise, unfortunately we aren't able to support you with the expenses for travel, but like you said, there's quite a few tribunals in and around London, so if you find that you might be in London for a few weeks and you're wanting to do a case, then we can keep an eye out for any London venue tribunals that have cases coming up and sort of keep you aware of them. So there might be opportunities that you can sort of run a case in the space of a few weeks, particularly for Social Security. We normally get cases in with between 2 to 4 weeks notice, so you might be able to run a case within the space of 3 weeks, meeting the client, writing submissions, going to the hearing and then closing it, and that will be possible. We've had volunteers before who've been studying in Bristol, and they've had sort of reading weeks or spare weeks where they've then commuted between London and Bristol. So we've also been able to help them while they're running cases. And also with employment tends to have a lot more notice to the hearing, so you might find you pick up a case but the hearing's not going to be for another 3 months. So there might be opportunities where you'll maybe spend a week free where you've got work to do and you'll do that, and then you can go back away and study, and then you might pop up again a few weeks later. We just ask that you try and keep in contact as much as possible, and try and be as flexible as much as possible. But if there are real travel issues around it, do speak to one of the legal officers, because they'll be probably the best people to tell you whether they think it will be feasible for you to run the case, or whether they think maybe you should just hold out and keep an eye out for another case that comes, which might be better for you and more suited for the time that you've got to run it.
Thank you. I think we've got time for one more question. I'll try for 2 questions. I'll come here and I'll come back to you then.
I just really wanted to ask a question about commitment,
Mhm.
because obviously, just I guess piggybacking on that case, I work full time. In terms of coming in for an appointment for a conference or coming in for to look at submissions, how would that run if I'm working 9 till 6? So would I be able to come in the evenings?
Yeah, we do have some volunteers who work full time. Sometimes they're able to sort of get a break during their lunch break, and they might pop in quickly if they can. We also have a late office opening on Tuesdays, so the office stays open till 8 p.m. And a lot of the volunteers will utilise those extra 2 hours to do their work. Again, if there's any problems with it, do talk to us first, because there might be scope. For example, if you've got submissions and you aren't able to get in the office, then we might be able to look at them and have email correspondence about them, as opposed to you physically being in the office. And we can send submissions by email to some of the tribunal centres. So that might be an easy way that you can work around it. But just ask us and we'll figure out ways that we can make it easier for you to volunteer with us. But we do have volunteers who are full-time who sort of use either their lunch breaks, or will take off an extra hour here or there in the day for conferences, but often will come in during our late opening on Tuesdays.
I'm going to come to you now, but I would say that if you did have a question that you wanted to ask and we haven't had a chance to talk about it today, I think the FRU website is very good and very useful, so it could be that your questions could be answered there. And Deborah may have time, I don't know, to speak to you at the end of the talk as well. But your last question, please.
I'm also in Bristol. I was just wondering, in terms of the January training day, if we were to undertake training in January and then maybe focus on university work for those 5 months, could we come back and take a case in the May-June time and work and volunteer over summer, or is there kind of like an expiry date on the training?
Yeah, there is an expiry date on the training, but it is 12 months. So if you attend a training day in January next year, if it takes place in January, then we ask that you pick up your first case within 12 months of attending. So you don't need to pick one up straight away. You might find things crop up and you aren't able to, but so long as you come back within those 12 months and pick up the first case, and it's just picking up the case, you don't actually have to have completed the case within those 12 months. Then you'll be fine to still carry on volunteering with us in that way.
Yeah, can we thank Deborah in the traditional way?